Welcome to The Explainer. Today, we're going to break down a legal case that all started with something pretty simple. Kids, their scooters, and a couple of, well, really confusing emails. So here's the big question. Can your HOA actually ban your kids from playing out in the street? I mean, really? Well, that's exactly what one homeowner in Scottsdale, Arizona wanted to know. And he was so serious about it, he took his homeowners association all the way to court to find out. All right, let's get into the details here. The whole scooter controversy really kicks off in a community called Legend Trail, and we're talking about early 2021. And really, this whole thing boils down to two specific dates and two very different emails that came from the Legend Trail Community Association. Okay, so check this out. The first email sent on March 31st seems super clear, right? It says, ATVs and motorized vehicles, scooters, are not allowed to be driven on the Legend Trail streets. Thank you. I mean, that's it. Short, direct, seems like a done deal. But then, fast forward almost 3 months. The HOA sends out another email. This one's a clarification. They're basically trying to walk back that first message, saying, whoa, hold on, we only meant that for the private streets. They claim they don't have authority over the public ones, but, for at least one resident, this was way too little, way too late. And that's where this whole thing goes from a neighborhood squabble to a full-blown legal challenge, because one homeowner, Vance Gribble, decided he wasn't going to let this go. So on July 26, 2021, he went ahead and filed a formal petition with the Arizona Department of Real Estate. His big claim? That the HOA basically just made up a new rule out of thin air with those emails, and that, he said, was illegal.
So let's be clear about what Gribble was arguing here. He wasn't just saying he was annoyed. No, his core allegations were pretty serious. He said the HOA broke Arizona state law and they violated their own rules, the CC&Rs. The big point he made was that these emails weren't just words, they actually had an effect. The kids literally stopped riding their scooters on the streets because of them.
So, how did the HOA respond to all this? Well, as you can probably guess, the Legend Trail Association denied everything and came back with a completely different take on what happened. And this is really what the whole conflict boils down to. On one side, Gribble's saying a new rule was created through email. On the other side, the HOA saying, nope, an email isn't a rule and that first one was just a big mistake. The entire case pretty much hangs on which version of the story is true. So the HOA's defense was pretty straightforward. The board president, Terry Klein, even testified that the March email was a total mistake. She said it was only supposed to go to residents on the private streets in one specific area, Parcel A. The second email, in June, was just them trying to clean up that mess. And crucially, they said they never actually held a vote or took any formal action to ban scooters everywhere. Okay, so you've got two sides that are completely stuck. They're at an impasse. So the whole thing gets referred for a formal hearing. The case was officially heard on October 15, 2021, in front of an administrative law judge named Valva Moses Thompson. So yeah, this is no longer about emails. We're in a real legal setting now, where a judge is going to make a final call. Now, this raises a really important legal question. In a situation like this, who actually has to prove that their side of the story is the right one? Well, that's where something called the burden of proof comes in. It's the obligation to prove what you're claiming is true. And in this case, that burden fell squarely on the petitioner, Vance Gribble. It wasn't up to the HOA to prove they were innocent. It was up to him to prove they were guilty. And the standard he had to meet is called preponderance of the evidence. Now, that sounds fancy, but it just means he had to prove his claim was more likely true than not. Think of it like tipping a scale. This isn't a criminal trial where you need proof beyond a reasonable doubt. He just had to tip that scale of probability, even just a little bit, in his favor. So, the judge heard all the arguments from both sides. What was the final verdict? Well, here's what the judge found. There was zero evidence of a formal act of the board to create a new rule. Nothing. No record of a meeting, no vote, no written consent. And when it came down to it, the evidence just didn't show that the HOA had actually prohibited kids from their recreational activities. An email, it turns out, is not an official act of the board. And so the conclusion was pretty straightforward. The petitioner, Mr. Gribble, just failed to establish his case by a preponderance of the evidence. He couldn't tip those scales in his favor. The petition was dismissed. Simple as that. The final order from the judge, dated November 4, 2021, put it in no uncertain terms.
It is ordered that Petitioner Vance Gribble's petition against Respondent Legend Trail Community Association is dismissed. And just like that, the great scooter dispute was officially over.
So what are the big takeaways from all of this? Well, if you live in an HOA, there are a few things to keep in mind. First, communication is absolutely crucial. A single, poorly worded email can spiral into a huge legal mess. Second, process is king. An HOA can't just make up rules in an email. For it to be valid, there has to be a formal documented process. And finally, the burden of proof is very real. If you're going to take on your HOA, you're the one who has to bring the receipts and prove your case. Which really leaves us with a fascinating question, doesn't it? When is an HOA email just an email? And when is it something more? As this whole case shows, that line can be pretty blurry, and sometimes the only way to figure it out is in a courtroom.